Welcome to the Vehicle and Traffic Law Training Courtroom Testimony. This afternoon we have Judge Richard LaBue here from the Rochester Traffic Violations Bureau. He has extended us a courtesy in doing this training, and we would just like to extend our sincere appreciation on behalf of the Safety Department and the facility for taking time out today, sir, to do this training. What the judge is going to do, he's going to do a presentation on vehicle and traffic law, some courtroom testimony, and then after that presentation he will open it up for questions and answers. If you do have an urgent question that pertains to the judge's topic, if you could just raise your right hand and the judge will take your question. Everybody who's got a radio, please turn them off. This is being videotaped for future training purposes. The entire department will view this videotape. And the sign-in sheet is being passed around. Please sign in. Thank you, sir.
All right, thank you, sir. Okay, as you know, I know most of you here. I'm Judge LaBue in the Rochester Traffic Court, and I handle all of the summonses for moving violations that are issued in the city of Rochester. I also handle any, as far as the DWI stops, I handle the chemical test refusals, also all the fatal accident cases and accident cases that occur in the city of Rochester. Your grounds, of course, are totally within the confines under our jurisdiction within the city of Rochester. And you have the same police authority as any other police officer as far as goes the facility grounds and all of the persons who may enter these grounds. I'm the Rochester Traffic Court judge, and when people come into my court, you're as on an equal footing with any other police officer. That be the state police, the sheriff's department, the RPD, the park police, whatever it be. When you walk in that courtroom, my expectations of you are the same as any other officer who walks into the courtroom. And that mainly applies to your testimony and the elements of the charge that are required on each and every charge. That brings me to the issue, what brings me here today? All right, in my observation of the last 6 years that I've been a Rochester Traffic Court judge, I practiced law most of my adult life in Rochester, but just want to state this, that I find that there's a great divergence in the testimony presented from officer to officer, from police agency to police agency, and I would like to try to get it on an even keel order. Any officer who comes in on a traffic stop or some kind of a moving violation, that you all have the same, the knowledge is the same, that the elements of the charge are the same. And not to say that in one day Officer Stowell could come in and testify in one manner, and then another day Officer Seymour comes in and testifies in a different manner. It shouldn't be that way. There are certain elements to every charge, and there are some unique charges that I feel that the officers are getting into that perhaps the background and the training has not been as great as can be in the past. So what I'm trying to do today is to get you on an equal footing with every officer that comes into court as far as mainly the types of tickets that are issued on RPC grounds. Okay, and I can't stress enough that on the Rochester Psychiatric Center grounds, you are the police department, even though you might not have the weapon on you, and that's by a state mandate. That doesn't in any way negate your role, as you are the officers on these grounds. You're responsible for the safety and the welfare of any person or animal or thing or object or property within the confines of the RPC. In some instances, your authority could extend outside of the grounds, that being for an investigation of somebody who's on the grounds, the pursuit of a person perhaps who was involved in an incident on the grounds that carries you outside of the area. While you'll have to tie in with other police agencies, you're still an integral part of the surrounding community too. All right, basically, as the sergeant said, how you doing?
How you doing?
I want to talk about some specific charges that are most commonly written up by you officers here. And I noted in the last 2 years, the most common charge is failure to stop at a stop sign. We have a lot of stop signs out there. Specifically, though, I want to talk about what elements are required in testimony to support the charge of failure to stop at a stop sign. All right, first point. By the way, your summonses are outdated. When we moved from the Hall of Justice, the bottom portion does not have our current address on the bottom portion of your tickets. We're in the Sibley building now. And believe it or not, the fact is if you don't write on the bottom of the summons the correct address, it is a jurisdictional defect on the ticket. Minor detail you may think, but if it doesn't state on the summons where the person has to respond to that ticket, the ticket can be dismissed on its face for being facially flawed. All right. On the summons itself, you always should note on the back end of the summons notes pertaining to the stop. The notes should be made what they call contemporaneously with the stop, meaning while you have the person stopped on, let's say, a stop sign. At the time you're writing the summons, don't waste the time of the motorist or of you by completing everything on the back. But shortly after the stop, you issue a summons, failure to stop at a stop sign, you write the summons out. Before you leave the scene and send the, so you leave the scene, you complete the back end with what exactly happened, where you observed the car come from, what approach they made, were they eastbound, westbound, what was the name of the street, was your observation from how many feet, was it obscured, was it not obscured, was there another person with you in the vehicle, were there any independent witnesses? The back of your summons, a lawyer will rake you over the coals if he asks to see your summons, and he has the right to do so. He or she has the right to see any document you prepare. As a practicing attorney and prosecutor, that was a great technique that we used. I nitpicked on every summons, every box, and including the back. And if all your ducks are not in a row on that summons, you will lose the case. All right. So the notes are very important on the back end. Let's take a very common charge: failure to stop at a stop sign. All right. What's required? Number one, a direct observation by the officer in his presence. Direct observation. Not from a second party, not from what they call a hearsay, but you observe the vehicle. Secondly, you must testify that it was unobstructed. You had a clear and unobstructed view of both the stop sign and the vehicle in question. Now, here's one that everybody thinks is a redundancy and nobody likes to testify to. You must describe the sign. For instance, the sign was posted at the intersection of, whatever this intersection is, if there is an intersection. It was posted at least 8 feet from the ground. It was octagon by nature. It had red background with white letters spelling out the letters S-T-O-P. Now, a lot of people turn to me and say, Judge, the motorists or the defendant, Judge, what did they think I'm stupid or something? I know what a stop sign is. Regardless, you must testify to those elements. Now, not only, I'm not specifying just this agency, but other agencies in the state I have been a little liberal with on stop signs. And I've accommodated the officers because I know by listening to hundreds of thousands of cases when a person is lying or not under oath, the motorist. And I've given a lot of leeway to the officers on the stop sign issue. But technically, a lot of summonses would not be proven out unless you get those elements in. And I can't stress that enough. My liberality with that is there, but I'm leaning now a little bit towards tightening up on such charges as stop sign violations. So again, direct observation, stop sign, describe the sign, describe the intersection, and describe the approach. Now, what is a stop sign? Here's a nuance of the law. A stop sign is a traffic control device which indicates to a motorist that as they approach that intersection, they must come to a complete stop. Now, what does that mean? Folks, what that means, officers, is that it is not enough to say that the person stopped before a stop sign, because that's not what the law states. The law states that it is a traffic control device that indicates as you approach that intersection, you'll come to a complete stop. Reason being this: there are many parts in the state, and then specifically in the city, where a stop sign is maybe 8 to 10 feet prior to the intersection. And it would be senseless and useless for a person to stop 10 feet away from the intersection and then to whiz through the intersection. So it is a traffic control device. Okay? Speaking of traffic control devices, the catch-all violation for a sign is a sign, is the 1180A and D. Perhaps what do you use for traffic control device? 1180, the summons number would be the generic disobey traffic control device. If you feel the urge to do so on any type of sign violation, that means a U-turn, a one-way sign, a stop sign, a speeding sign, when in doubt, write the disobey traffic control device. Also, if you feel that this person should be, as you know, want to perhaps give them a break, whatever that means, the violation code to always go to is disobeying a traffic control device. A traffic control device is defined so open-ended in the state, it's unbelievable. The State Court of Appeals has held the only thing that is not a traffic control device is your vehicle. Your vehicle. So I understand you have 3 patrol-type vehicles out there. If you block a roadway, it is not considered a traffic control device. You cannot write a person up for disobeying a traffic control device if your car is out there. But if you're out there and you stand like this and say, stop, go that way, that's disobeying an officer. If they fail to do what you either command or what your vehicle commands, meaning you block the entranceway to the RPC grounds, your vehicle is parked diagonally or horizontally, you're blocking the roadway with your gumballs going. That is not disobeying traffic, that is disobeying a police officer, okay? That's a distinction that has to be made. I dismiss a lot of tickets for people, I don't know how often it comes up where you have to block off roadways, but it could easily happen here because you're dealing with a clientele that potentially you could have major problems here, rioting, all kinds of things. Today, why I'm here today, in fact, is because the city police and the state police are on the rallies that are potentially going to happen in the city today and tomorrow. That's what freed me up. But potentially you have the problem too. So disobey traffic control device is always a catch-all. Now, for a disobey traffic control device, that being no U-turn, that being one way, that being a stop sign, what is required? Again, the same elements that went into the stop sign. You have to prove that the sign exists by stating the dimensions of the sign, the location of the sign, the height of the sign, the dimensions, what the sign stated, unequivocal. Meaning, I have a one-way sign, Judge. The sign is posted at the intersection, northeast intersection of the roadway. The sign is black on white background. It has an arrow pointing in the westerly direction. Painted within the arrow are the words, one way. It is observable from any direction of the roadway. It is posted. All that's required, for instance, on a one-way sign is that there be a posting at each side of the road. There doesn't have to be one in the middle of the roadway. Meaning you have to have one, let's say it's Culver Road, I'm just thinking. Well, it would have to be at each intersection, crossing intersection of Culver Road. So if anybody came off of a side road, that would indicate to them that that is a one-way street. Now, a little nuance is, that means if they're coming out of a parking lot and they enter a wrong roadway, you don't have to have a posting at every entrance and exit way of the parking lot. Okay, so, and this comes up here. I get that a lot here because I guess you do have a couple of one-way roadways. That's a biggie here. And I just want you to know that can testify, but always get in the fact that the road is marked on each side with one-way posted signs. Visible, not obstructed by trees, not obstructed by snow, not obstructed by windstorms that have blown all kinds of dirt and dust on the thing. Use your judgment. I mean, if it's a poor snowy day and you can't see the sign yourself, don't be out there writing a ticket for disobeying a traffic control. But if you can't see it, he couldn't see it or she couldn't see it. Your judgment call on your part. All right. By the way, questions. Anytime you can interject with a question, but as the sergeant mentioned, more preferably would be after the presentation. I want to get into things that are tailored to you. So if I'm speaking a little too general, please let me know because I can tailor it as narrowly as you want it to be. All right, let's talk about towing vehicles. One violation specifically that I have not seen written up here is too much. It's unlicensed operation. But this is a biggie for you too, because you make a stop, a bona fide stop, you have to have probable cause for that stop. Now, probable cause is the person is on the grounds and did something moving, or they did something non-moving, but you're suspicious of the person. Let me get into this. The U.S. Court of Appeals held 4 weeks ago that mere suspicion on the part of an officer, now this is not abuse of powers, now this is legitimate now talking. I trust everybody here would not want to stop anybody on a whim. But the U.S. Supreme Court held this, that a police officer or an officer of your status in a security position has the right to stop an individual if they suspect that there is suspicious activity occurring either in the vehicle or by the individual. Now what this entails is this. Let's say it's 3 a.m. I don't know if your grounds are open and the public at that hour. I don't know for the facility, but you see some fishy person out there get into a vehicle. You know that person doesn't belong on this facility at that particular time. The law states this: if that person gets in a car, you have the right to stop the question and question the person. Okay? This is an extension of your police powers. You can extend your police powers on suspicion. Mere suspicion alone will support charge. But what happens is it has to be reasonable. Reasonable suspicion, meaning you can't on a whim. If you see somebody coming out of a high security area of your facility, stopping the person face to face is one thing, you always can do that, but to give yourself a higher threshold, let's say you see a car parked, if the person gets in the vehicle, then you have the full gambit of the law to protect you. And that's number one, you can search him. Secondly, you can search the car. Thirdly, you can search each and every passenger in the car. Fourthly, you could pat him down. Fifth thing, you could search the glove box. Okay, now why I bring this up is, I would assume, based on just my own knowledge, that a lot of people who here at the facility are either residents here or outpatients here may have been drug users, may have been alcoholics, whatever. Well, that would bring rise to the presumption that perhaps a lot of persons that come in and visit these people may be involved with drugs, they may be involved with alcohol, they may be involved with some criminal. Not to broad brush it, but if they do, this is an opportunity for you to stop. So I just want you to know that not to, if you can't draw the distinction as far as what's reasonable suspicion and not, then don't stop a person for it. I mean, in your own mind, you have to have a lot of reason to believe that this person is doing something, to say generically, fishy. Okay? All right. All right, let's say on a regular traffic stop, you stop a person for failure to stop at a stop sign. At the time of the stop, you look in the vehicle, you observe an open bottle of beer. All right, the law says if you see an open bottle now, you don't write the open container law anymore, which is municipal. You write driving with the consumption of alcohol in the vehicle. The law has changed on this. Consumption of alcohol means you do not have to observe the person drinking anymore in the car. But the fact is, under your belief that if you see an open bottle of Budweiser between the console of the car and the passenger and the motorist, if you draw the assumption that this person was drinking and driving, write them up for consuming alcohol in a vehicle, which is one of your code violations. All right. Let's say you stop the car, you write them up for failure to stop at the stop sign. You write them up for failure to consume. Your first question, by the way, is what? You don't tell the person a violation, right? Under police procedures, you approach the vehicle. May I have your license and registration, please? That's question one. The person's going to say, what did you stop me for? License and registration, please. Go back to your patrol vehicle. I understand you don't have nice VIN, unfortunately, which is a terrible thing, but I won't get into that now. But whoever you contact to do your record search at that point, stay in your vehicle, tell the person to stay right there. You go back with the license, registration, and insurance card, generally. If you are unable to access the police records at the time of stop, if that person is unable to present you with a license, they're unlicensed operator. That's the ticket. Failure to produce. Write them up for unlicensed. Let me determine if they're licensed. Person says, I don't have my registration card with me. Even if the sticker is valid on the car, unregistered motor vehicle. Fails to present you with a valid insurance card with a date that's accurate and matches the card, uninsured operation of a motor vehicle for failure to produce. All the city officers, all the state police, all the sheriff's department, you and the park police are on notice that that is the violation. I'll determine if the person was registered, unlicensed, or, okay? Meaning, at all times, I guess you're not going to have ability to call a dispatcher and hook up to the computer system. When in doubt, write the ticket. Okay. So you got this person stopped. Let's say you got a distaste for this person. They're really giving you a hard time. So you start to look for stuff, right? Uninspected car. So always check that inspection certificate on the window. Very easy to do. There's no grace period on inspections, by the way. Types of violations like that. But what I think I'm trying to get at is there's a lot of paper violations that are not being written here. And that would be unregistered, uninsured, unlicensed, things that are uninspected, or what we call paper violations. They bring rise many, many times. Most of the OMH officers who come in, the tickets are solely based. It's either failure to stop at a stop sign, boom, that's the end of it. Rode wrong way on a one-way street. Maybe you're just all trying to be nice people, which is fine. There's nothing wrong with that. We're not out to get everybody. Because a lot of the summons that are issued here are against employees. And boy, do they give me hell when they come in. Doctors in particular. You know, I worked at OMH. I'm a grade 97. I can't possibly get this ticket because I am the director of blankety blank. But the officer is the officer and has the authority over you on any issue regarding anything on the grounds as far as your safety. I always repeat to these people, it's your safety that they're looking out for. What, you know, the stress is to be on them. That if they weren't there and you had a problem at the facility, who would you turn to? You know, you're going to call one of the patients? No. All right. So what I'm saying is, don't negate the authority you have to write these paper violations. Okay? Right. Equipment violations. I don't think I've ever had an equipment violation written by an OMH officer, and that's fine and dandy. I mean, it's up to you. It's your prerogative. I guess, you know, there's about 25 of you, Sergeant?
About that, sir, yeah.
All right, and most of you are inside work, and you're, you know, but those that do patrols, and also failure to signal turn, you can write it one of two ways. You could write it as a moving violation, failure to signal turn, or you could write it up as the measly little equipment violation. A lot of this is up to your discretion. You have a lot of authority out there. You go either way. I can't reiterate enough. You are the cops of the RPC. And if you see a violator, failure to signal, and you want to get them, stop them. Okay? And if you feel like it and it's your day and you say, flip on that indicator switch to see if that thing works. And if it does work and you know that he failed to use it because he or she failed to, because they wanted not to use it. But broken equipment is another thing. I don't get any tickets from most of you officers here for broken equipment. Broken equipment is taillights, headlights, failure to use, failure to dim a headlight, muffler violations, loud muffler violations. None of these tickets ever come in, and they bring the basis for you to stop a car and to go through other aspects of the vehicle. On an equipment slip, now let me put it this way, there's a big divergence in law on it. A tinted window, you see excessive amount of smoke glass on a car window. The law says if there's 70% of the light from outside that blocked out, you can write a summons for excessive glass, tinted windows. Second part of that, the law does not require you to use any kind of device to determine whether the window is tinted. The naked eye, not mine because I got red eye right now, but the naked eye
I could tell if a window is too tinted. You obviously can because you've done traffic stops. You don't need what's called a tint meter. Tint meter is a little device that you put over the window and it gives you a registered number of what percent of light comes in. This is a violation that's never been out here. I went through the parking lot today and must have found 15 vehicles that were in violation. Now, they're not moving, they're parked, but let me just tell you. Okay. All right, tinted windows, a non-repairable violation. It's not a form where, I don't know if you know about these repair slips or not. Now, under New York state law, any legal equipment that goes bad, such as a tail light, a headlight, a muffler, under our laws, you have basically 24 hours to get the thing fixed. And if you fail to get it fixed within that 24 hours period, I can't dismiss the ticket. The man in the moon can't dismiss the ticket. It's a non-dismissible ticket. You stop me for a broken tail light, you stop me, Judge, let me see your license registration. Check it all out, your tail light's broken, I'll give you till 1/2 hour before sundown tomorrow to get it fixed. There's a repair slip. Your people have the repair slips. All right. You're courteous, you're generous people, you're professionals. You give them a repair slip, you tell them, you have till tomorrow. At the back of the slip or in front of it tells you when to get it repaired. You must bring it back to one of you, to an RPD, to a state police, to any officer or any mechanic, certified mechanic, and bring it to me, because I'm the only one who can dismiss it after that. They have to appear in court within 15 days of getting a ticket. They have to get the repair done in basically a 24-hour period. The only exception to that is a Saturday. If you issue a summons for an equipment violation on a Saturday, we give them till Monday. Like in summer, it'd be till 8 o'clock at night, 8:30 at night. All right, let me mention a few things. All the violations for equipment fall under section 375 of legal traffic. Now, some are equipment violations and some aren't. Okay, as I told you, tinted windows is not. Failure to use headlights is not. Okay, it's dusk, it's 9:20, 9:30, 9:45 at night. Somebody's leaving the facility, no headlights on. That's a moving violation, folks. That's not an equipment violation. One headlight out, equipment violation. Two headlights out. High beams on, not an equipment violation. Moving violation. No front plate. This is a big one. Wish I had a nickel. I tell the motorists, I wish I had a nickel for every motorist that comes in with no front plate. It's a non-equipment violation, non-repairable. No front plate. In New York, you have to have 2 plates mounted on the front, never in the window. One in the front, one in the back, securely mounted to the bumper of the vehicle. The violation, by the way, goes up to $200 in fines. That's how serious New York State takes this violation. Personally, I don't see it, but that's the way. I had 3 people in this morning with this one. Plastic covering on a plate. There's a state trooper that issues these night and day. I won't get into names, but that's night and day. I mean, I get 100, 150 a month from this one trooper. It's illegal to put any covering on a license plate, even clear plastic. Illegal. It's a violation of 4021, plate violation. Punishable $40 to $200 in fines. If you see 2 coverings on the front and the back, you could write them up twice. It's clear plastic, smoked plastic, anything, they're all illegal. Oscillating lights, pink lights, neon lights other than white light, illegal in New York State. Plate coverings, you got these blue filaments, purple light. Those are illegal to start with. They are not equipment violations. Again, for an equipment violation to be given a repair form, the device or the light had to be legal to start with. Tinted windows are illegal to start with. Oscillating light, purple light, pink lights are illegal to start with. Therefore, they're violations under the code, but they're non-repairable. A very important distinction, because if you give them the slip they give me, they come in and say, the officer stopped me, said, take this form down to the judge and I could get this thing dismissed. Number one, they're 40 days late on the ticket. I can't dismiss it then. Secondly, the form can't be issued on an illegal equipment to start with. All right, we'll get into that, but that could be a biggie for everybody here, from my observation of the parked car stuff. Search and seizure, let's talk about that a little bit. Get a stop, you got a real character in front of you. Man, woman, kid, whatever it be, young person. Officer, what are you stopping me for? You went through the stop sign. You know, after you come back. You don't have to talk too much to these people, because the more you talk, the more problems you get into. Okay, let me do the talking when I'm recording. All right, but anyway, you believe, once you observe this person, that there's reason for you to believe that there might be some criminal type of activity or something criminally related in the view, meaning drugs in particular. You look in, you see a bowl of hashish, you see have the aroma, and you see some pills, you see this, and you know they're not prescription drugs from the local psychiatrist here. You have reasonable cause then to ask the person to get out of the car, to pat the person down, to search the entire view. You can take the trunk open, you can take the glove box open, you can look behind it, you can basically pull the car apart. Let's say you got the guy down there and you want to impound this car because it is unregistered. If the car is unregistered and the guy can't show you that this car has a registration and you've got him pulled out and he doesn't have a license, don't let him drive this thing home. Stop the car, do one of two things. You park the car or have him park the car at the facility. You tell him, here's a quarter, go make a phone call. You get a phone call to call anybody you want after you issue the summons, or you possibly may have arrested the guy. Let's say you haven't arrested him. You know, you haven't found anything. You issue the guy a couple tickets, but you know he's unlicensed and the car is unregistered. Or if the car is just unregistered, you can either impound the vehicle by having it towed, which I understand might be a problem there, because you don't have the towing ability as the city does to get things towed out of here. Or you could call RPD and have them come down and tow. Or just have the person have the car stay there. Don't have the person drive it. Folks, if that car is unregistered and it's uninsured, and the guy's unlicensed, guess whose neck is on the line? Yours. Okay. You could be brought up on charges for letting a person unlicensed to drive. All right. Now, again, I don't know your total ability to look at nice, but aggravated unlicensed. I don't get any from here. I don't know why, because I get about, every day I must get 15 to 20 of these. What is aggravated unlicensed? Aggravated unlicensed means that the person, the motorist, is driving with an open suspension. Now, an open suspension results from one of three things happening. Either I suspended him or some judge suspended him saying, you're off the road, buddy. You don't have a license, I'm taking it. You owe the state $500. You have no authority to drive. I sent him a letter to that effect. I pull his license or whatever at the time. That's one way. Second way that a guy gets suspended, I'm using a guy generically here. Person has a ticket, throws it in his glove box, never gets it out for 3 months later. I issue a failure to answer summons notice to his house. This guy got a ticket, he didn't answer guilty, he didn't plead not guilty. I sent him a notice saying, you failed to come to city court, your licenses, driving privileges are suspended. If we see you or your car on the road, it will be impounded, you will be incarcerated. That letter goes out. Guess who's got to do the incarceration? Boom, you. I'm not out there with a baton in my hand. All right, third thing is, the guy came to court, I fined him, I set a penalty on him, I might have transferred him to the city criminal division. He tells me, Judge, I'll pay this thing by Friday. And I'm pretty good with you. I don't stick it to him. Okay, I'll give you till Friday. Friday comes and goes. No money. The guy owes the state $200. Immediately I send out a suspension order. If they don't meet their end of the bargain, they're suspended. Right, this character happens to be on the road. Then 2 weeks later, you stop him. He has a license on him. Somehow he didn't turn it in. I told him turn this thing in Friday. He has his license. He gives it to you. You see it's valid. But he has 4 suspensions against him. You wouldn't know it unless you hit some kind of a nice bin or some kind of a... Again, Sarge, I don't know what you have here technically, but if you have the ability always to hit a dispatch to get a run on this guy, if you've got open suspensions, you can arrest him, and then you call the Rochester Police Department and you can incarcerate him. It's a criminal offense, driving aggravated and licensed in New York. You spend the night in jail. Yes?
Judge, we do have a DMV hookup. It's reliable about 75 to 80% of the time, and it will come back and indicate that there is a suspension or revocation. And we do make occasional AUO arrests. In the event that is down, we do have a backup system where we call city records, via telephone by the dispatcher, and you can get more detailed information as far as vehicle registration, driver's license, warrants. So we do have some backup systems in place.
All right, that's good. On that violation, again, on like unregistered, unlicensed, it might be difficult for you to investigate each and every stop. But many times, by the way, presentation of a card doesn't mean that the card isn't insured, or these tickets, these cards come out 6 months before the expiration of an insurance policy. So, but it is difficult, I understand. But I'm glad to hear that about the AUO through. You do have the ability to check suspensions. That's a biggie, opening up that area of the law. I do get those summonses if they're transferred back to me, but they originate in the city criminal division. Okay, motor vehicle accidents. Guys coming out of this roadway here, Troutman or wherever, smacks into a car on South Avenue. Do you have jurisdiction? Absolutely. You have concurrent jurisdiction, what the law calls concurrent jurisdiction. Guys, at the corner of your facility ground ends where the city's street starts, but you have the right to stop the vehicle, investigate the accident, get an MV report out, 103A, fill out the report, call the RPD if need be. If no need be, if nobody is bringing charges of any criminal nature, you write the MVA report out. Our report. You say you might have an internal report, not good enough. It has to be the state of New York motor vehicle accident report detailing the accident. And when you come to court, if they fight this thing, you're 99.9% of the time a ticket should be issued. The RPD is under general orders. No accident will be investigated unless a ticket is issued. That's their general order. A ticket should be issued to somebody. Who makes the determination? You make the determination. I don't know what your access roads are out of here, but what's this, Elmwood over here?
Southwood Drive and Elmwood Avenue.
Elmwood, all right. You're pulling out, somebody's pulling out of your grounds in Elmwood, boom, gets hit by a car in Elmwood. The car on Elmwood was 14 feet away. This guy, Joker, decides to pull out. Failure to yield the right of way. You have to have seen the accident? No. When do you see the accident? How many times could you see the accident? You're in the grounds, out of the grounds, doing a report. But you have to put together evidence that indicates that this violation was more likely than not to have occurred the way that you wrote it up. Now, what are the best ways to do that? One is a witness. If there's a witness or the people in the car other than the motorist, you can get what's called deposition from them, supporting deposition from them. You have deposition forms, sir?
Yes.
Yeah. All right. You get a uniform ticket issued based on information collected by other persons at the scene. Now that is called hearsay. Hearsay testimony is, and I repeat, is admissible in my court and administrative courts. Is admissible. And 9 times out of 10, the only court on a traffic type thing that you appear in is our court, my court. All right. Now what that means is this. You get to the scene, you talk to motorist A, vehicle A, driven by Joe. Joe is the guy who's coming on RPC, he's an employee. He's leaving at 1 o'clock in the morning, whatever his time. Pulling out, Joe says to you, "Officer, I'm pulling out of this place that I work. This maniac comes down the street and smashes into me." How far were you from the intersection of the street? Well, that car must have been 300 feet away. Okay? Joe, get it down in writing. Start writing all this stuff down. Joe, give me a deposition. Would you mind giving me a deposition? Joe fills out his deposition. The car was 300 feet away. I was making my right-hand turn onto Elmwood Avenue, blah, blah, blah. I was in vehicle 1. This guy was driving like a maniac coming down Elmwood. Okay, fine. You leave him in the car. Don't let these two parties cross. You talk to Mr. T. Mr. T, what happened? I'm coming down South Avenue or Elmwood Avenue, and all of a sudden this nut comes out of the RPC grounds, and I'm only 12 feet away from him, and I slam on my brakes and smash into his leg. Mr. T, give me a deposition to writing, testing to that in your presence. Then what do? You look at the cars. You say, well, the damage to vehicle 1 was left quarter panel front, wheel well, indicating that the guy was not just about to turn out into the road. Vehicle 2, the vehicle that was coming down homeward. Damage to the right front headlight, taillight, quarter panel, maybe a little bit to the door, the passenger door, indicating the guy was trying to swerve. Folks, you got to testify to all this stuff. That number 1, you observed the damage to the vehicles. Number 2, that the damage that you observed is consistent with the violation of failure to yield the right of way while leaving a roadway or a driveway. Third thing, you must present the documentary evidence. You have to show me this stuff or I don't know it exists. This is very important. If you have any supporting documents, you have to get them in on the record, or I don't know they exist, and I don't ask you for these things. Motor vehicle accident report, Judge, I submit for evidence motor vehicle accident report prepared by me on such and such date. This is a document maintained by the Office of Mental Health the Security Force in the normal course of duties. I submit that document. I admit it into evidence. Judge, I took a deposition from Mr. T on such and such date. My signature personally is on this document. I prepared it on or about the time of the stop. Judge, I submit that as evidence. It's evidence as Exhibit B. I accept it. Judge, I talked to Joe, an employee of the Rochester Psych Center. He has this document. I prepared it in his presence. I witnessed it in his presence. I signed it. It is a document maintained by the Office of Mental Health or the Rochester Psychiatric Police Department or Security Department. In a normal course of duties, I admit it into evidence. Boom. That stuff's got to come in, folks, or I don't look at it. I don't ask you for this stuff. This is another biggie. Officers will come to me and say, Judge, why did I lose the case? You didn't give me any. You didn't give me a piece of paper. You didn't give me anything. MVA, you want to lose an MVA case, just don't submit anything. Don't bother writing the ticket unless you can support the charge. That's what I'm saying. Don't write the ticket unless you can substantiate the charge. So MVA reports, generally speaking, I haven't seen any. I assume an accident occurs once in a blue moon out here. Now, under New York state law, no accident report has to be completed if the accident's under $1,000 in damage. So minor fender benders, no. But this is the little nuance. If either party wants you there, you must go there. You must respond. If they say, I want to talk to this officer, bring him up. You have to go. And don't cast these off to any other police agencies like the sheriff's or the police department. You write it. If it's on your grounds, you write it. You're the police here. And you undermine your own authority in the wake of it all. If you start calling other police agencies to do your police work, you're undermining your own authority. Okay. All right. Any questions so far? Because I'm hogging up all the time. Yeah.
Yeah. If a ticket, if you issue a vehicle and traffic ticket resulting from a motor vehicle accident, does that ticket have to be issued on scene, or can that be a ticket that's written at a later time?
Okay. Any ticket can be written at a later time.
Mm-hmm.
The only thing is that the observation of the charge and the material that brought up that ticket has to be what the law calls contemporaneous with the stop. Now, you open yourself up to a lot of problems if you send a thing by mail. Is it legal? Yes. Mm-hmm. Can you go knocking on a guy's door later? Yes. The only times that I've seen, and I've upheld tickets for motor vehicle accidents that are after the scene, is leaving the scene of an accident. Biggie, folks. This is a biggie. Leaving the scene of an accident. If obviously you don't have the other person there. somebody runs back into this police station, and your security officer says, I was hit. You go up and you want a report done. Well, you do the report. Let's say the guy who got the plate number of the other car. Now, I don't know, now I might be getting into a little, I don't know what your authority is to go out, but let's say they live out in Hilton. You do, by law, have the authority to investigate the accident. As it occurred, it's where the accident occurred. The accident occurred on your grounds. Now, whether, as far as police procedures here, they want you to do that or not, that's a matter of policy set by the chief and by your command. I don't know what your commander is stating on that. I know what my answer is, go wherever the heck you want, because you have statewide authority if it occurs on your grounds. But if somebody does come in and complains to you and says, I was hit by such and such, here's the plate number, there has to be a follow-up investigation. You can't just issue a summons based on a plate number. So again, to answer your question, basically, if an accident occurs and you observe there's some other people, you should issue the summons right then and there. Yeah. All right. What radar speed? You don't have radar devices. You don't need radar devices, but you do need training. All right, under New York State law, there's 3 ways to determine speed. 4 ways, actually. There are bona fide ways to determine speed. Speed in zone, or a violation called speed not reasonable and prudent. All right, I'm a driver. We're all drivers, I assume. You know when a person's speeding. You have a good eye. You've been on the force for, let's say, at least 5 years, 10 years, whatever. The law says this. You can use a radar device if you're trained to use a radar device. Training, it could be on-the-job training. You don't have radar devices, so it's a moot point. Unfortunately, we don't have even one unit. All right. Secondly, you can pace a vehicle. Pacing a vehicle is constituted by you driving your vehicle for at least 1/4 of a mile behind another vehicle. And your vehicle is then picking up or losing a distance between you and the vehicle in front of you. And the vehicle, let's say, what's supposed to be 30? Supposed to be 20? 20? Well, you could beat speeders all day. Okay. I basically kind of dovetail this. I was at the airport the other day, and a couple of sheriffs, they're part-timers, and they were in a lot of speeding tickets. I stopped one of the guys, young man, and I said, why do you write these? Is it visual? And it's 20 there. At some point, it's 15. Now, here's a part-time sheriff that basically isn't earning his wings yet. He's, working 15 to 20 hours a week. And visually, he's writing speeding tickets. He hasn't lost one. I don't mention names. I never do, but I just mention them. But I'm just comparing it to your facility. You got a 20-mile-per-hour speed limit, and I've never seen a speeding ticket, which is okay, I guess. Again, this is not a criticism, folks. I'm not a critical kind of guy. I want you to know that. I've never been, I never will be. I'm just telling it like it is, okay? All right. But what we have is this. You got pacing is keeping your distance 1/4 mile, not gaining, not losing, but the clinker is when you testify that, to testify that you've got a calibrated device. I mean, it could be my speedometer in my car and it's off. So if you got to indicate, I don't know if your devices are calibrated or not. They should be, because every 6 months or they send these to active markets. Okay, but that's the second way, is pace. So radar is one, pacing on the third one is a laser. You don't have laser. Fourth one, visual. Ba-bum, dum, 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 dum. There's the one. You can all visually determine a speed. Get this one, folks. The law requires no specific training other than OJT. Now, this may be a surprise to you all here, but the RPD training for any officer who's been out is 12 hours. That's it. 12 hours, unless they're traffic enforcement. So in 12 hours of OJT, that means getting out there with a FTO who's trained in himself or herself
And observing cars, saying, that thing's going about 42, yeah, it looks 42 to me. That thing's going about 50, yeah, it looks 50 to me. Folks, you get enough experience in on that, and you know, as I know, I mean, I'm driving down Elmwood today, 30, 35, 36, guys going by me, 52, 54, 60, I don't know, but I know one thing, that it's like I'm standing still, going 36, he's speeding. I don't care how you cut it, he's speeding. How do you get around the little nuance of speed and zone not being able to target exact speed? There's a quirky little violation called speed not reasonable and prudent. Boy, could this be a biggie here. Because speed not reasonable and prudent, and I got the code numbers for you if you want them. Got thousands of codes down here. All right. What speed not reasonable and prudent is this? Based on the circumstances where you're employed, here in particular, you've got an excessive amount of incoming and outgoing traffic that people are problematic, right? They're either sick, mentally, maybe possibly physically. They're also having people coming in and out that are maybe elderly parents, elderly relatives. You've got outpatients that are living in, some of them in group homes or whatever. They're coming in to pick up medications or whatever. You've got some people psychotic, neurotic, schizophrenic. Where better than this facility can you have somebody determined to be driving with speed unreasonable for the conditions? No place that I can think of because of this. You've got people that are not perhaps 100% of mental capacity, crossing the streets, walking on sidewalks, don't know where the walkways are. You've got some joker running around here at 25, 30 miles an hour, and you think it's unreasonable? Based on the circumstances, write them up. Speed not reasonable, prove it. You see a sheet of black ice out there in the middle of summer, and it's middle of winter, middle of winter, and you see cars sliding all over the place, and you see some guy tooling at 22, and it could be tooling down at 22 because you're driving at 5, write them up. Speed not reasonable, prove it. You've got some kind of event here where you're on a security thing. I don't know what they might do here, but you might be outside with some event, or have the patients outside for a nice day or something, or some doctor might want to take them for a little walk in the fields or something. You see a car buzzing by and you say, I've got 40, 50 patients out here and this guy's cruising by over the lane cruise. Write them up. Will you win? Probably. Could you lose? Yeah. But the thing is this, you've made a determination, and I'll support that determination. Because your judgment means a lot to any judge. If you lose, think of it this way. You've rattled this guy cage, he's probably not going to go speeding through the RPC. He's going to get to court, he wants to fight it, or pay the ticket. The least that you've done is put him on notice. But we're not going to allow you to come around here and buzz around. Okay? Unfortunately, most of the tickets that I've seen here are employees that other than outsiders. And boy, do they give you guys, I'll tell you. All right. Slow-moving vehicle. Any questions on these? This is a tough one, speed not reasonable prudent. I know your chief is probably going to do flips on these type of violations. But, hey, they're all bona fide violations. The key theme is, folks, you are the police here. There's nobody else here. Okay. What do you want to hear about? I mean, I could talk for hours on I'll kind of pass it. You have any red lights on this?
Yes, at the entrance.
Red light at the entrance? Leave that one, I think, unless they're pulling out of your facility, that's your jurisdiction. If they're on the main highway, it's out of your jurisdiction. If somebody's pulling out and disobeys a red light, do we all know red lights? Red light is, it has to be solid, red, and the car cannot be in the intersection at any time. At any time, that light turns red, their car cannot be in the intersection. Now, this is a key one, because you enter the intersection, it's yellow, then you look up and it's red, and the other lights, they're in violation. Any time the car. Okay.
That includes when you're
Turning?
Yes, and you get stuck.
No. Turning is a different law. That's if you're in the intersection already and you stopped in the intersection to make a turn, you can expedite the turn.
Because you had right away.
Yes, you do.
got it right away makes the difference. And the other difference is you're stopped in the intersection. You're not moving. You know, you're not continuing. But that would, here's some big ones I thought of when I was in court yesterday. Failure to keep right. I don't, very little used violation. Guide even unmarked roadway. If the person driving isn't staying to their half of the road, and they're even over the line, or you think unsafely over the line, write them up. Failure to keep right. Another violation is failure to stay in lane. So there's so many there's multiple violation codes that you can think. But basically those duplicate each other. It's failure to keep right. Driving, how about this one? Driving left of a center line. You get somebody on the wrong side of the road. Incoming car, he's going the wrong way. Driving left of driving on the wrong half of the road. That's another violation, 1121. Passing on right. You got a car stalled out there, but he said, the motorist says, hey, that car's stalled. You know, he's been here for 5 minutes. Well, you've been at the corner, you saw the car just stop for an instant. Some other car decides to spin around him on the right-hand side. Okay. Passing on right. You can't pass on right. Okay. Except?
If car turning left.
True. Absolutely true. You'll make that determination. That's always a defense I get in court. That's where you come in thinking, because was the person actually turning left? You know, that's a notorious defense. Driving wrong way on a one-way street. We've gone over that a little bit. Failure to use the lane. All right, how about driving on shoulder of road? Do we get that here? Failure to yield. Oh, here's another good one. I want to get the elements of this. Failure to yield the right of way to an emergency vehicle. Now, when I came in here today, I went to Booker's, got a sandwich, parked at the DLC across the street, so I was a little early. I looked out on the grounds here and I saw a couple times the gumballs going on cars for whatever reason. One was a Jeep, another was a patrol. Now, nobody was on the grounds, no other cars around, but once those gumballs, when your lights are engaged, people have to stop, pull to the right. And they have to do so within 400 feet. Now, you have sirens in your vehicles? All right. Sirens or lights, or both, that's the law. You have to initiate on an emergency. It's sirens and or lights. I mean, sometimes you have an air horn or a horn. But if you have those things engaged, and some jokers block it, and you don't, obviously you have to get to your emergency. But if you don't have to get to an emergency like that, and if for any reason, it's not just, not just the fact that you have an emergency, but they have to respect the fact that you have those lights on. It could be for any reason. It doesn't even have to be bona fide, but it should be, for you to operate those lights. Well, let's say you just used them for some whatever reason. That person has to pull curbside to the right at all times within 400 feet. Failure to do so is the violation of failure to yield to an emergency vehicle. Very serious violation, folks. Fine that goes to $400. Also, full licenses left and right. Just for the very reason, you could be going to something that is crucial. And if you don't get there, someone can be dead. Okay. Here's another one I don't get too many. Failure to yield to a pedestrian. That's a chargeable thing to my court. Some person's walking through a intersection, they have the right of way. Crosswalk or no crosswalk. They're in the road crossing and that other car is a distance away. The person has the right to cross. Should you use crosswalks? Absolutely. Do you always have to use crosswalks? No. It's a judgment upon your part. Reasonable judgment. If a guy complains and wants a ticket issued saying, I'm walking across the street, this thing's barreling down the road and didn't let me go. Failure to yield to a pedestrian. Pedestrians have more status, especially in grounds like this. By the way, that code is 1151 subsection A. Here's another good 1146. Failure to use a horn appropriately. I get cab drivers on this one all the time. Beep, 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 beep. One's fine. twice maybe. Beep, 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 beep. Fair to use a horn. Correct, that's 1151. If it bugs you, write it. I get a lot of officers who bug about that. One of them happened to live at Park Avenue, one officer, she came out of her house and issued a summons on it. They didn't know there was a police officer, but she came out with her ticket. Seriously, it was like 7:30 on a Saturday morning a.m. and she was upset. And she issued a summons. I upheld it. Unsafe start. 1162. What is an unsafe start? Joe Camel's out from a school break, decides that he's going to go, hey, let's hang out at the RPC grounds for the afternoon. Gets his buddy and his new GTO, right? His old GTO. Decides to rev the RPMs up to 130 and take off. Kicks up a ton of gravel, smoke. You hear it, you see it, the stuff's flying all over. Unsafe start. Unsafe start is that violation 1151, which indicates to you in your mind that if this guy, he exercised poor judgment in starting the car, and he could have lost control perhaps of the car and fishtailed the back, and you've got all these hundreds of people here that they could be injured. Unsafe start. Serious charge. Anytime you hear screeching, revving up, pulling out, ripping off, peeling out, that's the violation. Insufficient turn signal. As you all know, anytime you make a turn, left, right, center, must signal the turn either by mechanical device or by hand. Not too many of these I get, but nonetheless, it is a violation. That's section 11. A lot of them I'm not going into the elements of because they are obvious. You observe it in your presence. Always the testimony. By the way, Sergeant, you mentioned you want to get into testimony. I will get into court testimony. But I'm going over some violations at this point. But, conditional licenses. I don't know if you see this. Conditional and restricted licenses. Person gives you stop the person at a stop sign. I see, after your license registration, you go back to your patrol vehicle, you find out it's a conditional license. Now, conditional license means this, and only this, that the person was convicted of a drinking, driving, or drug-related charge. Convicted. And me or some other judge decided that this guy should have the right to drive to work or to school, and maybe daycare for a kid. If it's a woman, I usually give her to daycare. A guy, I usually say maybe. But what it involves is this. The paperwork that I give that motorist or another judge has to be presented to you on the stop. You get a conditional license, the next question is, you have your paperwork with you, sir. If they fail to give you that paper, it's a very serious charge, but if you want to write it, failure to observe, failure to maintain a conditional license or abuse of a conditional license. The violation is violation is 1196 sub 7, conditional license violation. Again, if they fail to give you the paperwork, that is the violation. If they want to fight it, they could come to court. Anytime, folks, if you have an argumentative person at the end of your statement, well, you want to fight it, you want to argue the ticket, the procedure is 15 days to answer by mail, 30 days in person, the court's noted on the bottom. Make sure you have the right address. Don't sit there arguing with people. That's what our job is. That's what my job is. Okay, restricted use license. Again, conditional relates to drinking. What's a restricted use license? A restricted use license is that somebody came into court, was found guilty by me or some other judge on tickets, and out of the goodness of my heart, I determined that it would be too much of a hardship for me to take this person's license 100%. And I decided in my judgment that I'll allow the person to drive to work or school only, or both. Now, it's 3 a.m. on a Saturday night, and I get this all the time. The kid goes RIT, maybe he's hanging around here somewhere. You stop this guy. He gives you a restricted use license. Question, he has to have the paperwork, you have the paperwork, he has to present your paperwork. Failure to present the paperwork results in a violation of a restricted use license. And use your head, it's 3 a.m. on a Saturday. What school is this guy going to? What class does he come from? No place. What job gets out at 3 a.m.? Some, yes. But if he doesn't have that paperwork, it says, I'm a bartender at TGI Friday. Forget about it. The guy's guilty. All right. So that's important to know. Oh, here's a beauty too. Unattended vehicle. I bet you this is a beauty here. You guys pulling into the front of your place where I pulled in and you gave me the rights to park and I decided to park someplace else because I wanted to walk. But I'll tell you this. Some joker pulls up, doesn't know where he is, sees all these buildings, leaves nobody in the car. You give him 2 minutes, you give him 3 minutes. Out of the goodness of your heart, you figure out, hey, you know, give this guy a break. He just came in to see your desk down there. He's asking a question. Fine, that's okay. But 15 minutes go by, 20 minutes go by. You see the signs. He sees no standing, no parking, fire zone, police only, all these signs. Nothing happens. You can do one of two things. Write him up for the minor traffic stop, the parking stop, and go down to PVB if you want, parking lot. You could write parking tickets left and right. Or if you really want to get behind this unattended vehicle running, 1210A. Boy, is this a biggie. It's a heavy penalty. Because the idea of the thing is we don't want people parking in fire zones or anywhere else, and we don't want cars stolen. So, you know, what an invite for somebody to leave the car, the keys in the ignition, and the car running, you know, in the corner of, you know, the main entranceway to the RPC. I mean, all right. Folks, that's the violation. All you have to do is you have to identify the motorist and see him come in or out. Yes?
Locking doors doesn't constitute car being safe.
No. Locking doors?
Yeah, you lock the doors while it's running.
Oh, no. Oh, no. That's the violation. Locking doors, there's no impact on that violation. All right, backing unsafely. It's another one I think. By the way, they park like maniacs out here. These people, everything's diagonal. I found cars like this. I felt like it was in Mayberry, RFD, you know, like with, you know, little small town USA, you know. I said, these guys, don't they see these straight lines out there? Okay. But, you know, again, I realize that a lot of things you're confronted with, you have to kind of let go of this situation. And I appreciate that, because I'm not a hard nose myself. I may come off that way with this stuff, but I'm not. And your environment is much more strainful and more pressurized than some, and I appreciate that. But these are your judgment calls. I'm not telling you how to run your business, and you do a good job. All of you do a good job, and I've always stated that. All right. Backing unsafely means this, though. 1211A. Again, let's use this front where you've got the nice little cobblestone and all the nice little signs. And some guy decides to kick it in reverse and go backwards. And somebody's approaching. And it might be a patrol officer, and this guy decides to pull backwards. Backing unsafely. No accident has to occur. Usually it is an accident, but you observe the violation in your presence. The guy's ready to tear into you with his rear tail light. That's the violation. Opening door unsafely, 1214. Oh, this is a biggie here too, because you probably get wheelchair people and all kinds of stuff. Doors to have passengers leave a car have to be on the right side if the doorway's on the right side, left side if the passenger door's on the left side. Meaning, if you're on a roadway and you decide to discharge 2 or 3 passengers in the rear, they don't get out on the left side. You got to get out on the right side, passengers. People don't know that. That's section 1214. Opening a door unsafely. Here's a bit. I don't know how many fires you have here, but this is a serious violation. They take licenses on interfering with fire apparatus. Anybody's parked in an area or moved in cars and interfering with police or fire vehicles, that's a very serious charge. Driving on sidewalks. Let me just mention one more quick one before I take one. Throwing refuse. This is not a municipal violation. This is a traffic moving violation. Throwing refuse is 1220A of the vehicle and traffic law. Anytime, anything, including a bubble gum wrapper, is thrown out of a window, including a cigarette butt, folks, that's the violation. Now, do you write these commonly? No. Do people write them commonly? No. But a guy throws out an empty 6-pack of beer with the bottles, you better believe this is a serious violation. Stuff goes skewing all over the, you know, I mean, obviously, use your judgment. Bubble gum wrapper, a cigarette butt, you know, this stuff like that will disintegrate or whatever, but broken glass on the pavement is another matter. That section you could write under 1220A. No hands-on. Here's all kinds of violations on bicycles. I want you to know, I handle all the bicycle tickets issued in the city of Rochester. You all have the authority to write all the bicycle tickets you want. There's about 72 violations relating to bicycles. Bicyclists must meet the rules of the road of vehicles, of motor vehicles. I won't get into that. Here's a good one though. I could talk about seatbelt. Seatbelt. No seatbelt. Biggie. You've come in on a few of these. You've come in on it, right? Officer Reed. Yeah. All right. All you have to do is testify this way. You don't have to even get the street. A lot of times filler stuff goes on. I was on the facility grounds. My name is blankety blank of the Rochester Psychiatric Center. On 4/10/1999, I was driving on the grounds. I observed a 1980 Buick, colored red, plate numbers, zing, 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 zing. I observed the motorist who stands here before me. Made a left-hand turn on such and such street. He had the buckle, shiny portion dangling vertically on the left side of his shoulder. I observed, judged that he did not have a seatbelt on. I stopped him, issued him a summons 1229 C. Fine. Boom, that's it. But what did I say key on? The man who stands before me today, key. If you can't identify that person, boy, that's crucial. Identity. I have to know that the person you stopped is the person who stands before me on that date. Now, 9 times out of 10, that's what a document that they present. Judge, they presented to me a New York State license, and the pictured on that license was the gentleman or the woman that I stopped on that date of the stop. And this is the person, 100% identity. Or, judge, the person did not present to me a New York State license. He told me his name, he gave me a social security number, he told me where he lived, he told me his phone number. I went back to the records, checked, I determined that everything matched up correctly. He gave me a proper address. I believe today that the person I issued the summons is the person who stands before me today. Boy, I can't tell you how many people get off with identity issues. It's a number one defense. Not too much with you guys, but with the RPD, the notorious. You'll lose automatically like that if you can't identify the motors. And you have to get it in the testimony. Once in a while I'll say, how'd you identify? You know, because I'm trying to, work along. But many times I won't. I'll just sit there and let you do your own spiel. And if you fail to get that in, you'll lose. All right. Seatbelts. A couple other things. Any passenger in the car can get a seatbelt ticket, except adults over the age of 16 in the rear. A pet peeve of mine is no child seats. I hate that one. That's a moving violation, 3 points. You see a bunch of kids floating around in the car under, ages of, under 4, they have to be in car seats. If you get a passenger in the front seat adult doesn't have a seatbelt on, you have the option of writing up either the driver for 2 tickets or giving it to the passenger. There's a ton of other violations. I can't mention all of them. Yeah.
For the seatbelts, we can issue the driver, let's say there's, 3 kids in the back seat, not child restraint, they can all go to the driver.
Yes, sir. Yep.
What are our obligations if those kids are in the child restraints, as far as
stop
letting
the
them
car
go?
and pound the car and have the children picked up. And never allow children to be driven away. Yes.
Now, 3 kids, 3 tickets?
Yes. 5 kids, 5 tickets. The only option you have on, as I say, with the adults, front seat passenger, you have the option of writing You could either write the driver for both tickets for the adults, or give one to the passenger adult and one to them. But as far as the kids in the car, they all would be written against the driver. But keep that in mind about the seatbelt, by the way. You don't have, you know, if the passenger in front doesn't have none, you could write them up separately. A lot of officers don't know that. They think that they could write just one officer. So Q&A time, folks. I've done all the hogging here. Now I'll get into court procedure now. Yes?
Okay, I stopped a lady who drove on the grounds, who was dropping her kid off at the daycare center, and she didn't have her license on her because she just went from home back home. Do I have to be unreasonable and impound her car in those circumstances because she's unlicensed?
No, that's in your discretion. If you feel that it would be unreasonable for you to impound the car, then don't impound the car. But it would be reasonable for you to issue a summons for unlicensed operation. As a general rule of thumb, the city follows this, the state police follows this. As long as the car is legal, there's little authority for you to impound the car. You can, but as long as the car is registered and insured, the facts you do have, I would issue the summons for unlicensed and let it drive home, as long as the car was legal. Yes? Yeah. Oh,
Can I take you back to speed, unreasonable, and prudent? If I were to come into your courtroom, what do you like to hear as elements to that to be able to make it stick?
okay. Number one is...
With the observable.
Okay, the observable is this. First off, you have to what they call lay a foundation. The foundation is this. How long have you been with the department? How long?
2 years.
I have been an officer with the LMH for 2 years. I have 2 years of experience in patrolling facilities, and I have observed vehicles both on and off of the grounds. I can estimate vehicle speed, plus or minus 5 miles per hour, based on my experience and training on the job as an officer. That's very important, that plus or minus, anybody has to be within 5 miles per hour, by the way. But if you haven't gone out there and do it, you should do it with somebody paying has not. So you have to lay that foundation, and I can visually determine speeds plus or minus 5 miles per hour, Judge. Then I'll say, well, do you have any experience with radar? Do you have any LiDAR? Do you have any stalker? No, Judge. Okay, so I'll say you purely went by visual. Okay, so that's that. Secondly, you must state for that charge to be substantiated that there are some circumstances that existed at the time that made it unsafe and unreasonable for this driver to drive at such and such speed. Now, there's no unique speed that's known. It could be 15 miles per hour, or it could, you know what I'm saying, if it's a snowstorm out there and there's a ton of snow and people sliding all over, you might determine that 20 miles per hour is too fast. If you do so, those are the elements. Judge, there was ice on the ground, snow on the ground. I had a ton of people going around, walking all over. Animals were out there, kids were out there, and I determined that this speed was excessive for the conditions that existed.
So for me to come in and say we have signs posted 20-mile-an-hour speed limit,
Nobody cares about
wouldn't
the
be
signs. Nobody cares about the signs. Because the signs are not, that's speed and zone. When we talk about signs posted, it's speed and zone. The other one, any speed that you determine to be unreasonable, you use your judgment. I mean, trust your judgment. All right, any further questions? Yes.
What is the definition of dawn and dusk?
Dawn? All right, let me go with dusk. Dusk is considered to be, under the law, 1/2 hour before the sun goes down.
Sun goes what?
Down. 1/2 hour before the sun goes down. And it varies day to day. Dawn, I don't know, there's no definition of it as dusk.
Now, is that based on weather report, the guy on the television weather, or is that your own personal observation from, every night 9 o'clock it's dark?
It could be your personal observation. A lot of times in court, people will bring the weather report and say, Judge, at 8:26 p.m., it was o'clock. And I'll, I mean, I'll give 10 minutes, I'm not gonna be that tough. But the thing is, no, it could be your judgment call. It's like tonight, it varies every day. This time of year, it's always a minute or 2 or 3 off. Tonight, you probably get dark, what, 8:45 p.m. or something? So, it's a judgment. Yes?
Let's have a question. Say you have an incident here where we get called and we have a suspicious person, suspicious vehicle, okay, and we get called to, say, P12, our parking lots are numbered. So we, before we get there, we get a license plate, we get a description. Before we get there, this person's gone. We run a 1028 and we find out that maybe there was no registration for that vehicle. The person's the person's a visitor here that comes here once a week. The following week, that person comes back and you spot the vehicle during patrol. Is it reasonable to assume that that vehicle still does not have registration and stop that person and check the vehicle and the person out, being that that person did leave before we actually got there? Is that reasonable?
Yes, it is. The other thing is, once you make the stop, you have to again verify that the car was still unregistered.
Okay.
Because if they had cured that defect, it would not be unregistered when you stopped in the second time, after the second stop. But yes, the answer is yes.
Now, you write for consuming alcohol vehicle.
Yeah.
Now, in a continuum, you also have a potential driving while intoxicated is not driving while impaired because it's based on your reasonable cause.
Well, let's get into it.
Clause.
All right, Rich asked me, Sergeant Rich asked me this. It is probable cause for you to give the person a breathalyzer test. It's also probable cause even whether you see a guy in the night all the night. And I'm allergic, I have a high allergy, but you don't know that. A red eye, and it's late in the night, and you smell the odor of alcohol. There's what they call indicia of intoxication. To offer a person a breathalyzer at any stop, there's one of 6 things that have to be going on. One is you observe, they call it observe, that you smell the odor of alcoholic beverage in the vehicle. So that brings rise to what you stated. There's an open bottle there, or it was all consumed. Second one, you observe the odor of alcoholic beverage on your breath, which is even a stronger evidence. Thirdly, you had slurred speech. These are what they call indicia of slurred speech. Fifthly, bloody or watery eyes, or both. These are another indicia. The fifth one is resistance to your question. Totally shuts you right off. All right. If you have that indicia of intoxication, you smell the alcohol, you see a bottle of Bud on the floor, the guy looks drunk to you. Again, you may have a problem here because a lot of people are on medications on this facility that give that impression. But you have the right to just ask them to get out of the car. You have them do one of 3 field sobriety tests. It would be the legged stand, one-legged stand. I don't know if you're trained in this. Star astigmatism test, the gaze test, you're not. All right, so I won't get out of it. Let's just get back and roll this thing back. You have breathalyzer equipment. You don't have breathalyzer. Let me roll this back quick. You ask them, have you been drinking? They say, yeah, I had a couple of beers. You say, I'm going to detain you here, and then you're going to contact the case sergeant, there would be the RPD, right? And you detain them. You don't have to have a traffic ticket issue. You can detain them. So I want you to know that you do have the right to issue this summons. You can ask them, I'm going to ask you to take a breathalyzer test. If they fail to take, they say yes. You can write a summons for failure to take a breathalyzer, submit to a breathalyzer test. But you should always do this since you don't have, you
can't go beyond the scope of this thing by giving them all these variety fields of variety tests. You should at that point just detain the person and have the RPD come down. So yeah, detain the person. You always have the right to detain the person. And if it's 20 minutes later, it's 20 minutes later. Yes?
Being that it's that type of facility with medication,
Yep.
say somebody, they're driving and they are taking medication that impairs their judgment as far as driving. Is that a violation?
And it certainly is DWAI. DWAI is driving while ability impaired by either alcohol or drugs. Now, this is a little nuance. It could be legal or illegal drugs. Now, these people are on prescription drugs. They still may not be able to have the capacity to drive a vehicle. So yes, the answer to that question is yes. You have the authority to stop them, detain them, and have them submit to a drug test, which usually amounts to a observations by the police officer and a blood test. Many times what we get, we do get a lot of people, believe it or not, related to the facility, who live outside of the facility, who are consuming alcohol while they're on psychotherapy drugs. And that combination, as you know, is volatile. But when that occurs, I have very little mercy for these people. I have doctors come and testify, but unfortunately your hands are kind of tied at some point. You're going to have to turn it over to the RPD. But yes, by all means. I mean, you probably could stop a lot of people, under those circumstances. Anybody else have any questions on any procedures in court? Our court where we are. We're now in the second floor of the civil legal. Family court's also over there. What we have is we have 4 docketed times per day. They're 8:30 a.m., 10:30 a.m., 1 o'clock, and 2:30. On Thursday nights, I'm there until 7 p.m. We have the only night court. But there are 4 time slots that you could be slotted into. There's a police coordinator with the Rochester Police Department, Terry, the last name I don't recall. But she is the person who establishes times for you. So let's say you know what your schedules are. And if you could appear on Mondays at 10:30, you will get that time slot. Meaning that every time that you have to go to court, it will always be Mondays at 10:30. You're notified. You get your notifies to appear. You can designate your time slots that you want. Occasionally, if you designate a time that, let's say you can't get out of work, they could designate you to another time slot, which would allow you overtime, which the city police notoriously do because they get paid time in hand. But if you, let's say it's pertinent that you be here at work, well, you could designate a time slot that you're not here, and I authorize you for your overtime. All right. A couple things. You come in, you have 1 hour to appear in court. Let's say you're out for 10:30. You have to 11:30 to appear. Come in and you check in at our counter. You have your ticket with you, and you have your notified. You have the canary copy of the ticket, you have your notified. You come in, you wait the hour. If you fail to appear within the hour, you lose automatically. The ticket's dismissed for non-appearance of police officer. I let a couple go, but if it gets ridiculous, I get back to your commander and tell him this person's not showing up. Do something about it. In the city of Rochester, they dock the pay of an officer who misses twice at all. They get docked pay, and that's what this thing does. I'm not tough on this stuff, but if I get a real flake, I am. All right. You come in and testify, you wait the hour. You must retain the ticket for a period of minimum 6 months after you issue, after appearance in court. Reason, there's an appeal process. A person who comes to my court has the right to appeal the ticket within 30 days to a higher court. Sometimes the judge above me will reopen the case and send it back down to me and say, Judge, here is case again. I have no choice. It's a superior judge. I have to hear the case. So, but when I call you back, you have to come back with the ticket and the whole 9 yards. So always retain a ticket minimum of 6 months. I think it's policy in the city to retain it at least a year. The state police, it's 2 years. Some officers keep them for ages, never tear up tickets, never do it. So when you come in, the first thing you testify to is my name, your name. My name is da-da-da-da-da-da. I am from da-da-da-da-da. On such and such day, I observed. Always start out that way. I observed this motorist who identified himself with a New York State license at the time of the driving eastbound on such and such street. Approached the stop sign. It was lawfully posted with the 8 feet off the ground, red background, went the whole bit. I had a direct observation at that time, a date, and these, I'll get all the elements of the charge. I stopped talking, just end your trial, and I'll turn to you and I'll say, you have anything else to say? No. Now, you don't have to put in too much, and don't bring up elements of the stop that encourage the defendant to start attacking. Your job is you issue the ticket, this is the person, boom, that's it. You start saying, well, I had a brief Judge, I had a brief conversation with the motorist. At the time of the stop, he told me, blankety blank, 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 blank. Then what do I get notoriously? The defendant, the motorist saying, Judge, I never said that. And you know that, officer, pointed out. And you know that's false, don't you? And you're a liar, Right. As soon as that pops up, boom. Number one, I don't allow the defendant to start calling the officer a liar, and I cut him off from that. But if you want to open up a can of worms, get into small talk. Get into small talk, and I'll grant you 100% of the time it will come back to haunt you. It will come back to haunt you in court. And boy, there are some really situations that will make you feel that small because they're going to bring up stuff that you think you didn't say. And they'll have me believe that you said it. I also get people who say, Judge, all you do is believe the officers. Well, you're at a higher standard, there's no question. And yes, as a general rule, I do believe the officers. You're the ones with the wings, you're the ones with the badges. And I do hold you to a higher standard. But when you take the oath, you also have to be 100% honest. 100%. Because if I catch you in a lie, then you're in real trouble. Okay, because I can bring proceedings against you, and I have never done so, but I can have you badge. Couple other elements of the charge.
Judge?
Yeah.
Just back to that small talk there a minute. How about if a motorist admission that they
good point. It's not good enough.
should it be included in the officer's testimony as part of all the other things?
Yes and no, and I'll tell you why. I had a case this week. State trooper issued a summons. Monday he came in, and he was for speeding. And then later in the testimony, after all elements, and the trooper said, and Judge, also, on the back of my ticket, I have the motorist admitted to driving 75 in a 55 zone. Well, this set this guy up like a flame. I never said that. How could you say that? The thing is this, if you don't need it, don't put it in. And he didn't need it, because he proved the charge. He had his radar device, he had his visual. You don't need it, don't put it in. Now, sometimes, why I say yes and no, let's get into a motor vehicle accident case now. It's crucial that you get the admission almost, because you're not there. This guy, like I started you out, pulling out onto Elmwood. I didn't see him. I pulled out and he was there. You can get that in quotes. I pulled out and he was there. Well, then it refutes the fact that he's 300 feet away. I pulled out and he was there. That guy's 99% guilty, right? Because he didn't see the car. Don't forget, it's not a defense to say I didn't see the sign, I didn't see the car, I didn't see this, I didn't see that. No defense in New York State law, I didn't see it. Another thing, it's not a defense in New York State to say I didn't know that. Plastic coverings on plates. Who knows that? Very few people. Is it illegal? Yes. Do I give people breaks? Yes. But it's the law. What do you want from me? I tell people it's the law. I don't make this stuff up. I enforce it. I don't make the law. So you come into court, you finish your testimony, I make a decision on the case. There's a higher evidentiary standard, which you should know. In city court, it's clear, it's preponderance of the evidence, which means 51% of the evidence has to be tilted against the motorist, but the officer just a little bit towards that. But in state courts and our court, it's clear and convincing evidence. Our standard is something like 75% in favor, which is a much higher standard. The burden of proof on you is pretty high. It's not just like that, it's like that. So, you know, there's always the inference that the person walks in there is innocent until you prove the charge. You know. I'd say overall, we have the highest, Rochester area has 93% conviction right now. I'm not so proud of that, but I'm just saying that it's pride and glory on the part of you and the officers in the area. Because that's not saying that I'm just listening to the case, but it says that the officers are doing the job and doing it properly. We have by far the highest conviction rate in the state of New York, which is nothing to do with me. It's up to you. You guys are doing the job. Anything else? Song and dance? All right. Anything else? Any other questions? Okay, like I said, I could go over tons of our violations specifically, and I don't think that's required, but I want you to know we're available. I'm the only judge now. There's no other judge. When I say we, I mean me and my staff are available to answer any questions for you. There's 8 clerks we have that are very knowledgeable as far as the procedures that we follow, not as far as the legal. This is my name, this is my number. This is a direct line to me, on my voicemail or to my chamber. So you wouldn't have to be going through any other person. I'm there every day, Monday through Friday. It's a full-time judgeship. I can't practice law anymore, so I'm there all the time. I've been in this business for most of my adult life, prosecuting cases, appeals judge. I've done this for the last 6 years. So I do have quite a bit of knowledge of this stuff. All right, so if you ever want to call me with any kind of questions, feel free to do so. And I thank you for your time. I thank you for your listening and your participation.